Anna, may I take advantage of these 2 minutes before we start to ask if your the name of your employer is just Abby, or how do you pronounce it? It's Abby, right?
It's Abby, right? Yeah, you get it.
Yeah, perfect. I see Danilo has now seen my messages, so I guess he is connecting now. All right, everyone is here. Hello, hello. Bom dia, Danilo.
Bom dia, Luca. Hello, excuse me for the delay.
I think we can get started. So whenever we are ready, I'm waiting for Carnegie's friends' guidelines. Can we start?
I think we should go ahead, Professor. Yeah.
Okay. So good morning. Are we already recording? Everyone is joining in. Can the technical support of Carnegie confirm I can go? Yes. Yes. Excellent. So good morning to everyone. Welcome to this session on data architectures in the BRICS countries that is organized jointly by Carnegie India and by the CyberBRICS Project at FGV Law School in Rio de Janeiro. It is hosted by the Center for Technology and Society at FGV that I have the honor to coordinate. My name is Luca Belli. I'm professor at FGV Law School, and I have the pleasure and honor to coordinate the CyberBRICS Project and CTS FGV, the Center for Technology and Society at FGV. Today I will briefly introduce this workshop and moderate the panel. After my brief introduction, there will be some key points and a further setting the scene moment with Konark Bandari, who is Associate Research Fellow at Carnegie India. Thank you very much for this, and thank you very much, Carnegie India, for having put together this excellent session. And then together with me, there will be in BRICS order Professor Danilo Doneda, who is professor at the Brazilian Institute of Public Law, where he leads the Center for Internet and Society Studies. He's also a member of the National Council for Data Protection and Privacy, which is a very interesting advisory body of the National Data Protection Authority. Then we will have Anna Korshina, who is a Privacy and Data Protection Council, ABI, in Russia. Thank you very much, Anna, for being with us. Then following up in BRICS order, we will have Smriti Parshira, who is research fellow at CyberBRICS Project. Then we will go on with Wei Wang, who is PhD candidate at the University of Hong Kong and also a research fellow at the CyberBRICS Project. And then last, but of course not least, Sizwe Ka Ntuze, that is a senior partner at Snail Atomies at Law, and is also professor at University of Fort Hare and University at Nelson Mandela University, and last but not least, of course, also a member of the South African data protection regulator InfoReg. Let me just start with by showing a very brief presentation to set the scene and for you to have a little bit of idea of what we are going to discuss today, and mainly why we are going to discuss this. Here you see the very nice introductory flyer that our friends from Carnegie have developed. Thank you very much. And here you see a very nice tool that you find on cyberbrics.info that actually explains why we are really here today, I think, this kind of discussion, because BRICS countries, which are usually considered a very low-profile grouping, but very interesting, fascinating grouping, I would say. They have been adopting new data protection laws. They have been updating their framework. They really have revolutionized their data architectures over the past 2-3 years. If you want to check how they have been doing so with regard to personal data protection, I really suggest you check this tool that is available on cyberbrics.info. And you will see that some major changes have been happening over the past couple of years. Our panelists will delve into the details, but just to give you a brief overview, Brazil has just enshrined 2 weeks ago data protection as a new fundamental right in Article 5 of its constitution, and has enacted a new data protection law, general data protection law, completely as of August this year. It gets created a new authority, the data protection authority. Russia also has updated in March this year its data protection framework, after already having updated it a couple of years ago with data localization requirement. India is almost adopting its new data protection law after having enshrined a new fundamental rights of privacy in 2017 with the Putaswamy case. China is the only place on earth where policy making is faster than technological development, where only in 2021 there has been a new Chinese civil code with the right to data protection, a new data security law, a new general data protection law, and there is currently consultation on guidelines to regulate algorithms and also data transfers. South Africa, again, last but not least, has been enacting finally POPIA, its general data protection law, that after 1 year of grace periods finally entered completely enforced in July of this year. So really some major changes in all the 5 countries that encompass for more than 40% of the world population, 3.2 billion people. Now, if you want to have a better understanding of the general picture of how BRICS countries have been regulating data protection together also with other key dimensions that we have considered as key dimensions of cybersecurity regulations, I suggest you check this book that you can download in the website of Springer, or also in preprint version in an open access version on cyberbrics.info. And why the BRICS countries have been converging in these data architectures is not a coincidence. If we analyze BRICS digital policy makings, we see that since 2013, actually, I would say as a reaction to the Snowden regulation, there has been an increasing interest in digital policy making. Since 2013, there has been an interest, a commitment to elaborate universally accepted norms, standards, and practices in cybersecurity. This has been expanded not only to cybersecurity, but also to encompass also data protection and security of ICT infrastructure with the Xiamen Declaration in 2017. And then last but not least, of course, at the very recent 13th BRICS Summit that took place in India under the Indian presidency in September, the BRICS leaders actually crossed the Rubicon. And for the first time, not only they stressed their engagement to respect privacy of individuals, to work together towards universally agreed norms on the security of ICT, but also they underscored the importance of establishing legal frameworks of cooperation among BRICS states and to enact and advance some intra-BRICS cooperation in this domain. This is a key step in BRICS digital policy cooperation that actually explains why we are having today this conversation to understand if there is this willingness now for convergence. How are de facto the BRICS countries regulating their data architectures? If you want to have an understanding of how these intersect with cybersecurity, I suggest also you check this blog post that was published in the EU Institute for Security only a couple of months ago, right after the BRICS Summit. And then now, without further ado, before giving the floor to our distinguished panelists, I would like to give the floor to our distinguished workshop introducer. Actually, we have Konak Bandari setting the scene and allowing us to understand also on Carnegie's side what has been the thinking behind this today's event. Please, Konak, the floor is yours.
Thank you, Professor Belli. Hello to all the panelists and to our audiences joining us online. Welcome to the Carnegie India and the FGV Law School discussion on data architecture in BRICS nations. Now, I think just to sort of pick up from what Professor Belli said, cybersecurity was a clear priority area identified by the BRICS countries at the most recent 13th BRICS Summit held this year in September. But even over the past few years, we have seen that there has been a trend towards talking about cybersecurity. As Professor mentioned, in the Durban Summit in 2013 was the first time when there was a call for cooperation on cybersecurity matters, especially talking about universally accepted standards, norms, and practices. So even though the approaches among the BRICS countries might seem disparate, over the past few years, we have seen this trend among the countries to sort of, enact data protection legislations and content moderation policies, and we'll see that now with this discussion. For instance, Brazil in 2020 enacted the data protection law called the LGPD, and strongly inspired by the EU GDPR, it entered into force last year in September. A lot of work needs to be done in terms of the implementation. As from what I've read in terms of the literature, there is sort of this culture of tolerance of data leaks, and that would probably need to be worked on before the law is strongly implemented in Brazil. Then you also have the proposed fake news bill in Brazil, which has been criticized for introducing traceability requirements that weaken encryption. So that's the scene in Brazil. Regarding Russia, Russia has enacted its internet sovereignty law, and the law essentially seeks to protect the country from cyber attacks. The issue in this law is that it basically allows the state to sort of disconnect the Russian segment of the internet called the RUNet from the global internet if this were to happen. So that's a highly contentious point in terms of what Russia has gone about doing. India has earlier this year notified its intermediary guideline rules, where essentially you had two sets of people, the publishers and the significant social media intermediaries. As per this new guidelines, essentially social media networks which have more than 5 million users have an obligation to now basically enable the tracing of original message, basically the message originators. This is a highly controversial view and will probably run into some opposition in terms of judicial action. Regarding personal data, Professor Belli already touched upon this. The Indian government is expected to come out with its latest version of the personal data protection bill in the upcoming parliamentary session. China has also sort of in January 2021 come up with the codified set of civil code, which enshrines the privacy as a right in China. But also in August 2021, they came out with this PIPL, the Personal Information Protection Law, which essentially will have sector-specific rules regarding privacy. In South Africa, you had the POPIA, which is the South African Protection of Personal Information Act. Basically, this act was given 8 years to become enforceable because during all this time, you sort of had the regulator being established and South African enterprises were given time to comply with this thing coming into force. Now, coming back to the BRICS 2021 declaration, the BRICS leaders expressed their intention to advance practical intra-BRICS cooperation. And they said that they wanted to go about doing this by establishing legal frameworks of cooperation among BRICS states. Now, this could be in the form of intergovernmental agreements or some other legal frameworks as well. So it's not exactly clear how the cooperation would happen, which is why today's session is so significant, because essentially the scholars will discuss as to what are the possible methods of cooperation among the BRICS countries. So I'm hoping today's discussion is going to be very fruitful in this matter. And that's pretty much it from my side. I now request Professor Luca Belli to take the proceedings further. Thank you.
Thank you very much, Konrad, for contextualizing this, and really also to highlight that it's much more than simple data protection. There are a lot of interconnections with a lot of other parallel and domains of digital policies that intertwine with data protection and data architectures. And indeed, there is a lot of work to be done. And this, I would say that this workshop has a seminal role to play into how scholars also can help design this intra-BRICS cooperation. I really hope that this will be the first step. Actually, with Carnegie, we are also thinking about a new event, probably during the Global Tech Summit that Carnegie organized to keep on feeding this discussion with new inputs and also multi-stakeholder inputs on how to produce this cooperation, this intra-BRICS cooperation. Now, without further ado, let me give the floor to my friend Danilo Doneda, to start explaining us how not only how Brazil has created its own way of data protection, but also how Brazil is innovating in terms of data protection. What is very interesting, I think, from BRICS countries, and together with Danilo, we have a new publication that is upcoming on this. It's really that they are not only, they are stopping being copycats, and they are starting to be innovators. And it's very interesting also to see how they are starting to innovate, to understand how they could cooperate. Please, Danilo, the floor is yours.
Thank you very much, Luca. It's a pleasure to be here to take CTS FGV Rio and also College India in names of Luca Belli and Konak Bandari. And it's an honor to be present with all my colleagues who will talk after me, and going strictly to the point which Luca mentioned. Yes, Brazil, as mentioned even by Konak, has a very new data protection legislation, which is still in the implementation period. For instance, we have the law, which is 1 year old, more or less, but the sanctions are effective since August this year, and our DPA haven't provided with no provision of when it's going to start is enforcement. So we are still in a very early stage of adoption. But going back a little, as Luca mentioned, Brazilian data protection legislative framework is not a copycat. It's a kind of autonomous system, which is very much based on existing rules. I would not only mention GDPR, even because when the first version of our law came out, there wasn't a GDPR. Even the leak of the GDPR of 2013 was after our first step. So in the drafted of the Brazilian data protection legislation, we counted so much on what appear to be international standards by the time, the Convention 108, even before 108 plus OECD guidelines, and most principally what was happening also in Latin America. Latin America was always a good example, a very good benchmark for Brazil. But interestingly, Brazilian dynamics on data protection is rather different than any other Latin American country. If you look to the time schedule, the time frame of data protection legislations in Latin America, you see that Brazil is very outside of the natural curve. 5 years ago, we had already most of the medium to large economies in Latin America already with their data protection legislations in effect. And Brazil not. Brazilian data protection legislation began to be drafted more or less in 2009, 2010, and we follow different dynamics, as I mentioned, differently than several Latin American countries. Brazil was not driven by the need to adapt to international transfer rules, mainly European rules, by the time, such as most Latin American countries did. Brazil followed a particular dynamic. So we had in Brazil the right to privacy constitution since 1988. We had the ABS data action, constitutional writ since 1988. We had some rules on data protection. We still have a strong consumer law which enters into data protection. We have the Internet Civil Rights Framework, Marco Civil da Internet, which is widely known throughout the world, which has several data protection provisions, but still we didn't have a specific data protection legislation, which was finally approved in 2018 and came into force in September 2020. It is different than other Latin American and global rules outside of the timing. Yes, I believe it's a bit different. We have in our law much of the legacy from consumer protection, which is stronger, which is very strong in Brazil. In Brazil, we have more than 900 regional consumer offices. And for instance, one particularity of our data protection enforcement system is that we have, yes, one DPA, the National Data Protection Authority, but our data protection legislation provides that any of each of these 900 consumer offices can be an authority on applying, on enforcing LGPD or data protection legislation, which is a very peculiar enforcement framework, which is not easily found in other countries. So we have a mix of enforcement authorities. We have the main authority, of course, the DPA, but we have also the provision in our law that any other public authority which happens to have some kind of concurrent competence on data protection because of its own competence. For example, consumer, but I would add also the financial regulator, the telecom regulator. All of them can use and will more certainly every now and then apply the data protection regulation. And this is one very important characteristics. Look, ask me to stress on particular characteristics. There are others. I have few time, but I prefer to stress this one, which is not. Even in Brazil, we don't know very well how this will happen because it can be so confusing. But for sure, it can be also a driving force in order to force our DPA to follow its mission, because we don't know as of yet how our DPA will act in difficult situations. And we have another particularity, which is that our DPA is not independent, is not autonomous at all, is a part of the direct public administration. It's located inside the Presidents of Republic. So it's, of course, obviously submitted to political power, which is not the best of situations with the DPA, needless to explain. But it happens also that if the DPA eventually fails to achieve its goals, to fulfill its mission on protecting the fundamental right to data protection, which is a constitutional right, as Luca remembered us, if the DPA eventually fails, we'll have other authorities, other public bodies who can came into the help of citizens of that subjects, enforcing on its way, on its own fields of competence, data protection. It's something to be seen. Other situations we can, I would like to stress that in the first year of LGPD, we have our DPA acting strongly on regulation, on its own structure. The DPA has a regulatory agenda which is being followed, yes, but as I mentioned, there is no provision on when enforcement will in fact starts. At the same time, we'll have the courts which are already applying our data protection legislation, we have a project in my university which categorizes and lists and analyzes all the legal decisions in the first year of LGPD. We could find around 600 decisions, and it's very interesting because they cover a wide range of subjects, since liability to transfer of data among public bodies. So that is another promising field in Brazil, which is to try to absorb and analyze what courts are making of LGPD. They are learning also, but we can see that at some points they begin to have some structure and kind of sophisticated views on some points of LGPD, which in Brazil we don't have. I don't have in some European countries, for example, which is the administrative enforcement, doesn't make impossible for the citizen to ask for judicial help. So we can most probably, we will have in Brazil both for the administrative and judicial, each of them playing a very strong role on specifying enforcement, the specific forms of enforcement of LGPD. And one last thing, I will profit that we are having this event with Carnegie India, and also mention that another subject, which is not strictly LGPD or data protection matter, but is related strongly, of course, to data privacy, is that we have a bill which is being examined by Brazilian legislator on internet freedoms and transparency, which includes a clause which would make mandatory for messaging apps to have some degree of traceability, which is very similar in some ways to what happened in India with IT rules 2021. This bill is not finished. The Congress right now is considering it, and one of the current text provides for some tools which aims to find the first sender of a message with disinformation or fake news or whatever, which has all the drawbacks we are stressing here in Brazil, and maybe we will be able to change this in the last text, but it's something very strongly related, I believe, with data protection, and is a very interesting similarity, because this Indian example is always mentioned here also. Thank you very much, Luca. I don't want you to use more time on this.
Thank you very much, Danilo, for providing a very good picture of how the situation on paper may look much clearer than what is in reality in practice in Brazil, and a lot of work needs to be done to put in practice this framework that may provide a lot of surprises for the practitioners, but also from on the side of the government in the implementation side, as many elements are still quite fuzzy and needs implementation. Now to move on to another BRICS country, Russia, that has also hitting the headlines over the past couple of years, also for this internet sovereignty legislation. I would like to give the floor to Anna Shurshina, that is here with us, and bring us a very valuable perspective also from the private sector, and how the data protection and data regulation in Russia is really being implemented, used, and can help or not the private sector in having a better understanding of how data should be regulated. Please, Hannah, the floor is yours.
Thank you, Luca, for the kind introduction. I prepared a couple of slides to accompany my presentation, so I will share the slides. Please give me some time to do it. Yes, I think you can see my slides. So let's start. Just a few words about myself. To add that I'm a Russian qualified lawyer. I'm a member of European Association of Privacy Professionals, holding several certifications from that organization. I'm specializing in privacy and data protection compliance in various countries, and work as a privacy and data protection counsel at global IT company IBM. So my talk will be divided into the two main parts. First is a history of the creation of the Russian data protection framework, and the second one is the current trends and recent developments in Russia. So let's start with the history. A right to privacy and data protection is guaranteed by Russian Constitution since 1993. Before the enactment of the specialized legislation in 2005, Russia ratified Council of Europe Convention for the protection of individuals with regard to automatic processing of personal data. Main ideas and concept of this convention became part of our legislation. So, for example, data subjects' rights, legal basis for data processing, and etc. And national legislation was enacted in 2007, and it was followed by the creation of the Independent Russia Data Protection Authority called Roskomnadzor. It's an abbreviation from the Russian full name. And Roskomnadzor has various powers. It's an important player of the Russian data protection framework. It supervises compliance protection laws. It has legislative powers, so its orders are binding for the data operators. And also important to say that our data protection legislation has two main definitions: data subjects, it is similar to the GDPR, and also we have data operator. And data operator is the entity who arranges or carries out personal data processing, as well as determines the purposes, scope, and actions performed on personal data. So if you will make a parallel with the GDPR, it's a concept of the data controller. And since Connected and Data Protection Authority was created, all companies try to incorporate new requirements into their work. And in fact, in the upcoming 6 years, nothing significant in terms of amendments will happen. So in 2014, data localization law came into force. It was enacted and came into force in 2015. So in brief, once personal data is collected, it shall be placed in the database located in Russia, calling primary database. And only after that, data can be transferred to the foreign countries. And due to the incompliance with such laws, some companies were heavily affected. For example, in 2016, Roskomnadzor blocked LinkedIn. And until now, Russian citizens do not have right to access LinkedIn without using specific tools, for example, VPNs, if they want to stay in touch with the international community. Also important to add that in 2016, the special pack of anti-terroristic measures were introduced. Before that, from 2010 to 2014, we had a number of terroristic attacks across all the countries. And now legislator decided that since those individuals who were participating in the organization of these attacks were using social messengers, using phones for their communications, they introduced data retention periods and obliged telecom companies to have such communications data to store for 6 months and to provide it to security services in case of the court order. And until now, any communication data can be taken by the security services in case of any criminal investigations. But anyway, all of this already history, so let's go back to the recent amendments. And I would like to focus on the amendments which were introduced in March 2021. They already enforced from the March, and they significantly changed legal landscape with regard to the use of the publicly available personal data. I will talk about it on the next slide, and before going to the next slide, let me briefly cover a new law which was introduced in July 2021, which will be enforced from January next year. Foreign companies with the online presence who has audience of the Russian users more than 500,000 users per day have to land in Russia. To land in Russia means to open branches in Russia, to open offices. And they also have another requirements to implement. For example, they need to register with Roskomnadzor. They also have to put a special tool on their website which can count users of their websites. But still, it's a little bit unclear how this will be implemented. And let's not to cover this in more details until next year. So let's focus on the March amendments. So according to explanatory note, of our legislator, the idea of new amendments was to prevent collection and uncontrolled use of personal data on the websites for the purposes different from the initial purpose for which it was disseminated. So, for example, before these amendments, any data which were publicly available, meaning that data subject made this data publicly accessible via posting it online, or if data subject directed another person to do so, this data can be easily used by data operators and disseminated for any purposes they wanted. After the introduction of such amendments, term publicly accessible data eliminated. Also, publicly accessible data definition was actually the legal base for the data processing. So now such legal base doesn't exist anymore. And there is a new definition, personal data permitted for dissemination by the data subject, meaning that if data operator want to disseminate such data for another purposes, it needs to get a consent from the data subject. And this consent can be given directly to data operator or via special IT system of the Russian Data Protection Authority, Roskomnadzor. It was supposed to implement this special IT system by July this year. Until now, Roskomnadzor created a web page, special web page on their website, which allows to download a template for providing the consent for the dissemination. It's a specific template which can be tailored by the specific case of the data operator. Also, this configured template can be submitted to Roskomnadzor. Roskomnadzor will check all the lines and will confirm or decline the template, and will give an advice to the data operator if this form can be used or not. So this kind of a very useful tool from our Data Protection Authority. Also, March amendments allowed our data subject to have absolute right to data deletion. So now a data subject can submit a data deletion request, and the data operator have to grant this request in 3 days. And the data subject should not attach any evidence that he has a right to such a deletion request. But before, it was on a data subject side to prove that his data actually should be deleted by the data operator. And of course, there is one nuance. This consent requirement is not required and do not apply to the data processing in the state or other public interest. So this is a brief explanation of our amendments from March 2021. And before ending my presentation, I would like to talk a little bit about situation on the innovations in Moscow. Just 2 weeks ago, Moscow Metro introduced a new system which allows passengers to enter the metro just without any additional tools like paying with the phone or having its travel card. So, for example, if you're going to travel to Moscow, you can use this link and to leave your biometric data. You will leave your photo images, and the specific processing algorithm will convert it into a specific ID key. And once you're going to the metro, you can stand in front of the camera, look at the gate, and the gate will allow to enter metro. So, as I read on the internet, the Moscow was the first metro system who introduced such payment system on the large scale. So here, very interesting how this biometric data will be used in the future. Of course, we have here opportunity not to use only just for the entering the metro, but also for some government surveillance, for the crime investigation, and etc. But at the moment, our metro authority, they told that this system is very fast, safe, and innovative. So I'm very keen to try it when I will use the metro in the next time. So this was my short presentation. Let me go back to you.
Yes. Thank you very much, Anna, for this very thorough presentation in such a short time frame. Very good to see how the situation has been evolving in Russia, and also how Russia is actively implementing this kind of technology that is based on a large collection of biometric data. And it will be very interesting to see in the next weeks, next months, how this will be reconciled with the existing data protection framework. Very interesting indeed. Now let's go to India. and with our CyberBRICS Research Fellow Smriti Parshira, India also has been hitting the headlines over the past months for a lot of different digital policy related issue. And finally, all the data protection community is expecting India to adopt the famous data protection bill that is in the pipeline since a couple of years now, and everyone is really trying to understand when it will be adopted. Please, Smriti, the floor is yours.
Thank you. Thanks, Luca, and thank you, Carnegie and CyberBRICS, for bringing all of us together for this conversation. So I also have a few slides, and as I put it up, I just observed from the discussions we heard so far how India is somewhat behind the curve in terms of what we've heard from other countries, in terms of both when the constitutional right to privacy was adopted, which happened in India only in 2017, as well as the conversations around the data protection bill, which, as Luca was mentioning, have been going around ever since I've been in this project with CyberBRICS. We've been talking every time we have a conversation. Luca is like, so what is the latest? And I still say it's pending and it's still under discussion. So a little bit more on that. But what I'll do is in the next few minutes also talk a little bit about some developments on the technical architecture side. So while the legal architecture is a bit of a pause mode, there are some developments on the technical side, and I'm going to talk a little bit about what's happening and also possible concerns around that. So just to begin with, the big question of, is there a data protection law in India? And the answer is both yes and no, because it's not like we have no data protection. We do have some limited protections available under what is called the Information Technology Act, but these are limited for several reasons. They're limited because they only apply to body corporates, so government agencies are completely out of the scope. They focus only on the protection of sensitive personal data, which is only, as we know, a subset of the personal data which deserves to be protected, and they apply mainly for maintaining the security of the data. So although through rules, a lot of other typical data protection regulations have been pushed into the rules, the statutory framework itself applies only to the security and the reasonable security practices. So it's limited for all of these reasons, and because there is no authority as of now to implement it, it becomes even more limiting, because there is some text in the law, but it's not really being enforced, audited, or viewed by anyone on what is the level of compliance. So to counter that, we've been actually for the last decade having a conversation about the need for a privacy law, a data protection law. And this has gathered steam, particularly in the last 4 years after a constitutional right to privacy was declared in 2017. And that led to the setting up of a committee under a former Justice of the Supreme Court, Justice Sri Krishna, which came out with a draft bill, which further went back to the government. They did further consultations and introduced a bill in December 2019. Now it's been about 2 years since that happened, and the bill has been pending with a parliamentary committee, which is across parties, across different houses of the parliament. This committee has been set up to review, because this is a high stakes matter. For such issues, these kind of committees are set up, and this committee has been sitting on it and conducting their own rounds of consultation and debate for the last 2 years. And what happened in the middle of this year was that because of some shifts in the government structure, the chair of that committee changed, because she became a minister in the government and she could no longer be on that committee, and therefore there is a new chair of the committee, which led to a new round of meetings and consultations, etc. And they've as per latest news, they're going to submit their report in the winter session, which happens anytime at the end of this month. And we need to wait and see whether another extension is in the pipeline or, that's going to happen. But I wanted to talk about some of the big issues. So, of course, the whole bill in its entirety is before the JPC, but there are some of the issues which have been reported in the press as thorny issues, which are generating some debate within the committee. And the first of those is, this whole bill that I've been describing is a personal data protection bill. It sets out rights, it sets out obligation, it sets out a data protection authority, but there's a parallel conversation happening about the need for a non-personal data governance framework. So there is another separate committee that was set up, and one of the debates that's now happening is that will this committee try to merge these two things to make this a data governance law and no longer just a privacy law? So both identifiable and non-identifiable information could potentially be governed under this law. And the idea is that there is a lot of non-personal data out there, which is, either it was never personal information like air quality data, or it was personal information which has been anonymized and is useful for third parties to use. And therefore the government and third parties should have access to this private data, proprietary data often, which is held by third parties. And there's a conversation going on in India about the regulation of that data. The second, big issue with the bill and the debates which are going on around is around government use of data. So this is a bill which is changing the status quo by bringing both the government and the private sector under a comprehensive data protection law. But it comes with the problem that it has very widely worded exemptions which are possible under the law. In particular, there's a provision which allows an entire agency to in entirety be exempted from the entire legal framework, and saying that there'll be separate rules that could be notified for that agency. And the really ironic conversation one heard, in the news last few days was that the UIDI, which is the National Identity Authority that runs the biometric ID scheme Aadhaar in India, is the one which has proposed that it should be one of the agencies exempted under this provision. And that's ironic because that litigation around the Aadhaar and around intrusive use of biometric ID is the reason why we had this committee set up and why we are having this conversation on a personal data law in the first place. And then to have that agency itself excluded is of course going to be a big blow, but we don't know where that's something they have proposed. We don't know where the committee is going to go with that. Data localization has been another very thorny, contentious issue in India. India has, unlike many other countries which have vouched for free flow of data, India has tried to reserve its policy space. Actually, not in this company, because a lot of countries have gone pretty serious about data localization norms, but globally there are a lot of countries which have, vouched for free flow of data, but India has said that it wants to reserve that space. And in the personal data space, there has been a lot of back and forth between the different versions of the bill about which data can be localized and which can be stored abroad and which can be processed abroad. And that's one open issue. And lastly, there is, of course, the big question around this one huge body which is being created to, do data protection for the entire country. It's across sectors, it's across private entities, across government entities. So the independence and accountability of this data protection authority is one of the big questions. And one of the members of the parliamentary committee has even said that, actually the bill right now proposes that there will be one national level data protection authority, and it could have sub offices, but it will be offices of this one authority. But there seems to be some conversation and some demands that this should actually happen at a state level. So India is a union of states, and the conversation seems to be that some quarters believe that it's not enough to just have all of this power and authority concentrated in one body. You need to have this spread across different regions. But I believe it's unlikely that would happen, but it is one of the debates before the JPC. So with that, I want to switch and spend a few minutes just talking about the technical architecture that I was talking about. This is on the consent management framework that India has adopted, is already rolling out in a few sectors like the financial, the banking services sector. And the idea here is to create a technical system. So we all know a lot of data protection laws around the world rely on consent. Even though we know consent has so many problems, we still rely on consent as the basis for processing of personal data. And this is a technical architecture that's been developed in India and is being deployed on using an electronic consent management mechanism, where something called a consent artifact has been notified. And what a consent artifact should look like has been notified by the Ministry of Electronics and IT in India. And they've set out certain benchmarks about who's giving the consent to whom, for what period, for what purpose, and all of that. And the idea of this framework is to have, let me just show you in a picture. Yeah, so this is from a discussion document released by a government think tank, Niti Aayog, last year. And it just gives a depiction of the entire architecture, which is being called the Data Empowerment and Protection Architecture, which in the center of this is this new class of entities called consent managers. And the idea is that there is one set of people who want information from users. There's another set of people who have this information. This is currently happening in the financial sector. So a bank has information about my finances, about what I spend on, about my regular statements. And someone who wants to give me credit may want to have that information to know whether I'm a credit-worthy person. And typically how this would happen today is I would take the data from one entity and pass it on to the other. And the whole idea of this framework is to eliminate that intermediation cost that I have to bear and have a third-party consent manager to do this, entire chain of transmission without themselves seeing or accessing or utilizing the data. They're supposed to be data blind entities which transfer data from one entity to another using this consent artifact in an encrypted manner. So that's the design of it. And as I mentioned, it's already been rolled out in the financial sector, also being rolled out in the health sector under a new national health architecture that we have. And in an upcoming paper, which is going to be published by the Center for Communication Governance here in Delhi, I take a look at this framework, and I'm raising a couple of issues. So there is obviously some good which is coming out of it, that is making, transaction rights tangible, it's making consent tangible, it's making portability tangible, and it's facilitating all of that through APIs. But there is also a little bit of problem with the way in which this is happening, not so much in the technical design per se. So one fact of this is the fact that the state is endorsing these technical standards, right? There is one standard which the state has picked up, which has been proposed by a private group, and the state has said, yeah, I'll put my force behind this in the financial sector, in the telecom sector, in the health sector, and I'm going to, push this. And the problem with this is that typically you want multiple standards to come up, and the best standard based on what the market wants will prevail. But when you have the state pushing a particular standard, the incentives to innovate, the incentives to compete and develop other technical standards really go down. And that creates the first layer of issues, is what I highlight in this paper. The second is, as I was mentioning earlier, this consent problem is much larger than what this architecture is solving. So it's solving an important problem of having an auditable record of who gave consent for what purpose and for how long. But the consent problem is also about my behavioral limitations. It's about the structural barriers that, I have no choice but to consent in certain situations. And by calling this an empowerment architecture, it's taking a particular brand of consent management and making it sound like this is the be all and end all of empowerment, which it isn't, right? Because one kind of empowerment is also having less data collected about myself. So the whole idea of this framework is that there is value in data, and I will derive that value if more data is available and I have control over that data. But it's equally true that I may believe that power lies in no entity having data or minimal amount of data being out there. But by encouraging this ecosystem of more and more data, it's creating reverse incentives for empowerment, as per what some users may believe empowerment stands for them. And finally, there is this entity which has created this whole framework. It's a private sector body called iSpirit, and now it's being adopted by government agencies. It's being taken forward away from that agency, but there is also a self-regulation which is being born out of this structure, where an entity which currently in the financial sector is an aggregation of account aggregators, consent managers, so to speak, who are going to self-regulate. They're going to set their governance norms. They're going to take the standard, refine it further. They're going to talk about how to do interoperability. But in the regulatory framework right now, there is no conversation about this very powerful self-regulatory, self-governance bodies being created. But who's going to watch this watchman? Because ultimately, if all of the consent management in the country lands up in the pockets of this agency, it has a lot of power about how data governance is going to work. So there are big questions about abuse of that power, and really concentration of that power in the hands of one or a few entities which become self-regulatory bodies. So I'll stop with that, and back to you, Luca.
Thank you very much, Smriti, for this. And really, it's fascinating to see the kind of approach that India is trying to experiment, and the fact that they might have a data governance law rather than a data protection law, combining personal and non-personal data governance is really interesting. The DIPA, the Data Empowerment Protection Architecture, is a fascinating tool, but indeed may be very beneficial, but may have huge risks. And it is very interesting to have a more critical stance to how this could be implemented in practice. Well, let's now move to another BRICS country that has also been hitting the headlines a lot, especially over the past week, knowing that the new General Data Protection Law of China, People, the Personal Information Protection Law, entered in force exactly this week, on Monday, on the 1st of November. So no one better than our friend Wei Wang can tell us a little bit of how data architectures have been evolving over the past months, a lot indeed, and years in China. Please, Wei, the floor is yours.
Okay, thank you, Luca. And thanks to Carnegie India and FGV for organizing this webinar. And a special thanks to goes to Luca for your invitation. And I have enjoyed the talks made by our colleagues as well. So I have actually one slide for to show the overview of the Chinese data governance. I will just share it. Okay, it's here. Oh, sorry. Okay. By the way, but I will just go ahead. Probably my sharing function today is a little bit something wrong with it. Okay. As we may all know, the Chinese Personal Information Protection Law came into effect on the first day of this month, and the Chinese have been witnessing almost every mobile app has been improving their terms of privacy and service. But you may want to know that the framework of the data governance in China represents China's emerging data protection architecture that includes a bulk of other laws, industry-specific regulations, and standards. Basically, we have a complex legislative structure on data architecture. For example, we have the kind of national security law, cybersecurity law, data security law, the Chinese Civil Code, personal information protection law, and the relatively recent draft amendment of antitrust law. And for those ministry level regulations, we have the kind of critical information infrastructure security protection regulations. We shortly call it as CII rules. And we have also some specific regulations for algorithms, for example, the Internet Information Service algorithmic recommendation management preventions, and the guiding opinions on strengthening overall governance of the Internet Information Service algorithms. So, but if we look at the big picture, we may understand the model at the kind of a three-layered approach, including protecting personal information, ensuring data security, and regulating algorithmic bias. So, personally speaking, I think China has now been putting kind of national security as the dragon head of data governance. For example, this kind of approach has been reflected in the mechanism of localization, cross-border data flow, and particularly the critical information infrastructure. For example, in the PIPO's Article 40, there is a kind of a rule on the security assessment, which states the operator of a critical information infrastructure and the entity that transfer a large volume of personal information must locally store their personal information collected in China and undergo a further security assessment to transfer if necessary. And also, this kind of approach has been basically reflected some very recent cases where we can see events. For example, LinkedIn and has partially put its some of its services from out of China, and Yahoo has fully put its services out of China. Then they heavily cited some compliance costs or something, and the regulatory environment. So probably this kind of we should consider, for example, risks, compliance, and market access issues in terms of protecting personal information. And another case is about the Apple, because I have noticed that Apple in China have been updating their terms of service and privacy terms. Basically, Apple update links users to their new policy, particularly the illustrations on the type of data they collect and how they would use and share it. And another characteristic of the national data architecture China that is kind of tried to show the data sovereignty. For example, it has a mechanism of blacklisting. And very recently, I think Luca has mentioned we're currently trying to introduce the measures for data export security assessments. That's a draft for soliciting of comments. And the final characteristic of the national data architecture is kind of China tried to increase the legal interoperability of the of protecting personal information. For example, if we look at the 101 road, if as some of you may know that China is trying to join the regional comprehensive economic partnership. Just last week, President Xi announced China's decision to apply to join the Digital Economy Partnership Agreement. So the kind of for example, so we can understand that the personal information protection law at the very first step to raise the bar of the personal information protection in terms of digital trade. And so finally, I would just briefly share some structure architecture of the data governance from the article 1 of the personal information protection law. We have the kind of a academic term that is the principle of incentive compatibility. That means basically it tries to strike a balance between regulation and innovation and even commercialization. Yes, that's what we call the principle of incentive compatibility. And another, and this kind of principle was reflected a phenomenon of that China introduced some standards as a normative instrument. For example, in the cybersecurity law, we have a kind of the data classification of the grade system that basically it's about a data catalog of important data. Basically, it defines what data are important in terms of the public in the opinion of the public authority. Okay, and if we look at the regulators, I mean the whole regulatory environment, we also can say that with the introduction of the data security law and the PIPO and the 2017 cybersecurity law, China's regulatory framework of data governance has become kind of 3+N model with the Cyberspace Administration of China, Ministry of Public Security, and the Ministry of Industry and Information Technology all playing key roles, in addition to some sector regulators' precise oversight. For example, for the central bank, I think yesterday or today, it announced that because financial personal information was regarded as a kind of sensitive personal information in China, and the sensitive personal information will be regulated in a more, stricter way. So the central government, because the central bank is introducing the digital yuan, as you may know, the digital currency thing. So the central bank says that the digital yuan operators can open 4 types of e-wallets for customers. The least privilege only requires the phone number, so it would be anonymized even to the central bank itself. So it's kind of the regulatory model is like a 3+N, and some of the ministries have their precise regulatory power as well. So I think I will stop here, and I will hand it back to Luca. Thank you.
Thank you very much, Wei. And I really enjoyed this last part where you were stressing that actually, the vision of the Chinese government is not really only about policies and regulation, but also technology and development, and how they are shaping regulations so that also can be compatible with the technological development that the government has in mind, for instance, with the introduction of the digital yuan, and at the same time, the categorization of financial information as sensitive information that indeed are not only covered by PIPL, but also by the data security law. So they have to be stored in China. That is a very interesting evolution that I think will also be will need to be further analyzed in the next weeks and months. And for sure, this is a very interesting topic that will deserve further analysis from CyberBRICS and our network. Now, last but not least, of course, let me invite Professor Sizwe Znail, who is not only a good friend and not only a professor of law, but also a member of the board of the Data Protection Authority of South Africa. And so he has a very interesting perspective of how data protection has been developed and then how it plays out in practice. Please, Sizwe, the floor is yours.
Thank you, Luca, and thank you very much for a lovely introduction. You know, when I looked at today's topic, I was like, you know, for the last 5 years, I've been selling POPIA, and finally, a couple of months back, POPIA actually became law. So it's been a very interesting road from the right to privacy in our Constitution, 1993, going to the first piece of legislation that dealt with some form of access to information, being the Promotion of Access to Information Act. And then in about 10 years ago, the POPIA was born. And with the birth of the POPIA also started the discussion of new cybersecurity norms, new cybersecurity policies, as well as the redesigning and the redevelopment of the South African Cybercrimes Act. Now, the reason why I mentioned these is because coincidentally, our president put the new Cybercrimes Act into law on the same day that the POPIA became now law after the 1-year grace period. There's something very important about this. What is important about this is that our government has seen the importance of cybersecurity and cybercrime threats, and also the fact that cybercrime, cybersecurity, and data protection actually do have a common denominator. And that is the confidentiality of data, the security of data, the protection of the data, and to ensure that no unlawful access has taken place. So I think considering, you know, the developments in the other BRICS countries, I must say I'm very proud to say that data protection is now a reality in South Africa. It is no more a like-have. It is no more a philosophical concept that can be discussed. It is now being tested. People can file their complaints, which are being attended to by the regulator. Shortly, we will get outcomes from the regulator. Some will be positive for others, some will be not so positive in the event where people have actually breached the data protection rules. You know, one has also seen there was a lot of confusion regarding the concept of prior authorization, who may want to apply for prior authorization, and why you want to apply for prior authorization. And we've seen a lot, you know, from the insurance sector, the banking sector, and obviously we've also heard the public discussion regarding social media companies and how they use our data. I was actually looking forward to hearing from Danilo as to how the Brazilian Data Protection Authority dealt with the whole aspect of social media companies using personal information and putting them to terms to ensure that they comply with the Brazilian legislation. But in all, I think BRICS as a whole has, you know, become alive to the fact that data protection, cybersecurity, and cyber criminality need to be protected. I think that is a reality that we now have. And, you know, in terms of cooperation, I think there will be a lot of cross-border cooperation, a lot of cooperation between the authorities in protecting personal information, prosecuting cybercrime, as well as ensuring that cybersecurity infrastructure and cybersecurity policies are put in place across the BRICS countries. Thank you, Luca.
Thank you, Sizwe, for this overview of the South African state of play. And it is very interesting to see that POPIA, the Protection of Personal Information Act, is now fully in force. And indeed, it is very interesting also to see how the South African government is trying to create actually an interface between data protection on one hand and cybercrime. And indeed, you are absolutely right. There is a lot of overlap between the two different but intimately intertwined subjects. And we have been discussing also this in our CyberBRICS book, analyzing also cybercrime as one of the dimensions of cybersecurity, together also with data security and data protection. Now, for this last part of this webinar today, we have a Q&A. I see there are already several questions in the chat box, so I will start by addressing them to all the participants. Some of them are more directed to specific speakers because they target specific country. But so let's start with the first one, which is quite general, by Syed Shah, that is asking what is the guarantee that the data provider, well, the data controller, let's say, is offering access to personal data to the users with permission of the data subject. So what is the guarantee that actually, this is a question about oversight, what is the guarantee that when asked to offer us access to personal data, the data controller will do so, and how this can be enforced in practice? Then we have a question that I think is more directed to Smriti and perhaps Konark, if he wants also to chip in, about India. So India has an edge with regard to the IT sector, but what role can India play to leverage its IT sector in its relationship also with BRICS country to trigger further process and further progress? And what are the key challenges ahead in order to India being able to play this role also of development powerhouse? And then we have a couple of questions by Varsha Sewell that also has been working with our CyberBRICS project. So the first question is, it will be helpful to understand how the DPAs regulate social media companies across BRICS countries. So if there is any idea of how the data protection authorities will be able to tackle social media and their use or misuse of personal data, and finally, if there is any idea of from other BRICS countries of how to regulate AI and cybersecurity. This is an open question that all speakers may dare to reply, but I'm not sure if we have a reply to this yet. So please, who wants to chip in and provide any insights replying to these questions? Anyone willing to start?
For me to start, Luke.
Please, Daniel.
Well, briefly, starting with the question by Syed Shah, he asks the guarantees that the data provider can give regarding information which it has stored, which can be given with the permission of data subject. I believe, Syed, that you are focusing on a consent basis here, in the sense that for the personal data stored and processed with the legal base of consent, it will be necessary to have the permission of data subject for every aspect of use, including the access. In this sense, the controls, the possible controls, are both technicals, but also the regulatory ones. by means of the several ways a DPA or a legal system has to deal with supervision. And so I believe that, of course, things which happens with personal data are not visible. So we have to trust in the enforcement framework. And this is something that is being developed in very different levels in several countries. I believe as a standard in BRICS, we are not as of yet in a situation with we have regulators with a large tradition on this kind of supervision. But I believe this will be necessarily a part of their job in the medium term, not in short term. I believe, at least in Brazil, because there are things yet to be structured. I have another question here of question by Varsha Sveil. It would be helpful to understand how DPAs regulate social media companies across BRICS countries. It's very interesting, even because it resonates with my friend's Snail questions. He mentioned that he was curious to know how the situation of social media data being used for credit score systems and for credit in general is being tackled in Brazil. Indeed, in Brazil we have a kind of, I would say, potentially schizophrenic situation where at the same time we have data protection developing and people are beginning to be much more sensitive for their social media data being used freely as it potentially were before, even by financial institutions and data brokers in general. At the same time, we have a very strong and flourishing fintech scene, which is developing. We have several fintechs. We have some small banks or small fintechs which are developing into financial institutions of some importance with millions of clients throughout Brazil. They offer very low rates, if not zero rates, instead of charging people as the traditional banks do. And I believe this is a very important sector. And as a rule, most of them, if not the great majority of these fintechs, uses all kinds of data in order to select the customers, to provide limits. And so they, in exchange for the zero or low rates, they do intensive processing of personal data. And I don't believe the situation is being tackled, it has even started to be supervised by the regulator, by the financial regulator, and even by our DPA. I believe that a balance will have to be reached in the near future, but it's not something that the fintechs are very worried right now. And from my point of view, this is something that worries me, because we are creating a very important players in our economy, which are being used to the almost free processing of personal data from the users. And when problems begin to surge, maybe regulator will pay attention. But as of now, there is no, I don't know of any intervention regarding this. Those were my points. I believe most of the other questions were more focused to the other participants.
Actually, if I can add very small comments on these two questions that I think is very relevant when we have in mind the data architectures and not just the law, is that a very key part of the architecture is the data subject as an individual that is aware of his or her rights. So the data subject, to be able to access his or her data, has to know that he or she has a right to it. And the controller or operator, according to the various denomination in the BRICS country, has an obligation to give to give the access to this kind of rights. And so a key tussle of the data architecture is also the individual is an aware, a person that is fully aware of his or her rights. So public policies also have to have an educational purpose in letting people understand their rights on one hand, and on the other hand, public policies have also a role to play in giving the resources to the regulator to investigate whether these obligations are fully implemented by data controllers, by the various entities process data. And to take the example of Brazil, for instance, it's always very telling to say that the Brazilian Data Protection Authority has 36 people working in it and overseeing the implementation of data protection in a country of 210 million individuals and thousands of companies and entities collect data. So really, it is essential in order to have an appropriate data architecture, also to put appropriate resources, both financial, intellectual, human, in the regulator. Otherwise, it is very nice to have on paper the law and the authority, but the practice will be completely disconnected from reality. I see. I don't know if Danilo has another comment on this. Otherwise, we can target the other question on India. I know that I saw that Smriti wanted to say something. So please, Smriti, the floor is yours. Or Danilo,
okay.
Danilo,
Danilo, do you want to say something? Yeah.
Just very briefly, just because Varsha's view, while I was talking, mentioned a question about the Brazilian DPA, ANPD. How did the ANPD dealt with WhatsApp privacy policy? Just to inform that our DPA, that was probably the first situation in which ANPD directly acted after some denounce, after some actual problem it faced. ANPD worked together with other three regulators, the antitrust regulator, the telecom regulator, and the consumer protection regulator. They called WhatsApp. They wrote some recommendations on transparency and other issues, and WhatsApp ended up agreeing to several of their considerations, and they even postponed, or even, I don't know very well if they really postponed it forever or they canceled, they will to implement some of the new privacy policies points. So this is important. This was most probably the first direct reaction of our DPAs. Just want to stress that. Okay. Please go on.
Yeah. Okay, I can take the question directed on India, where this is an interesting observation, because clearly India has been trying to leverage its IT power, its IT skills by exporting a lot of its tech design to other countries. I don't believe it has happened within the BRICS countries as of now, because I think all the other BRICS countries are at different stages of view, and a lot of them are using their own tech design. But clearly in things like digital identity, in things like the new app that was developed for vaccinations, the COVID app, India has gone all out and said to other countries that, we are willing to put the codes out, we are willing to help you develop your technology around similar apps. And then, of course, the question also asks about challenges, and there are massive challenges with this, because even within India, there are concerns about, whether these technologies are fully able to address the social and the legal context in which they are being introduced. And of course, the context is completely different in all the other countries where some of this tech may be exported, and that comes with huge ramifications, that it's not just about developing a certain technical architecture, it's about seeing through the whole layer of whether this is really suitable for each country's context. And that, I would say, is like one of the major challenges, that you take a digital ID program for a particular context and export it to another context, but it may be completely unsuitable, or it really compounds the privacy and other issues which might already exist in the other society. So that would be my response to that.
Thank you very much, Danilo and Smriti. Do we have any reactions from other speakers, as we still have 3 minutes to go? So if we have any final remark or reactions to these questions from the speakers, you're very welcome to chip in. I see Cesar raising his hand. Please go ahead, Cesar.
Thank you, Luca. That one question about regulating social media in BRICS countries. I think that one is a very interesting one. And I'll tell you why. It requires us not only to filter through the right of privacy, but it will also require us to filter through the right to freedom of expression. And maybe that is something that we need to look at, from a research perspective, to say, it's not just data protection, it's not just cybersecurity, it's not just cybercrime. One must also now start considering the right to freedom of expression and the right to access to information in the context of access to internet itself. So I think a CyberBRICS policy on social media, I think politically and legally is something that we won't see in the distant future. But I do think that the area of freedom of expression and access to information can be looked at more closely when looking at cybersecurity and data protection. Thank you.
Thank you very much for this, Cesar. And indeed, actually, we plan to expand the CyberBRICS project for the next phase into platform regulations in the BRICS countries. So this could be a very good topic for a specific paper and research in the next phase of the project. Anna, please, the floor is yours.
Yes, thank you, Luca. I wanted to add that during the developments of the Russian data protection laws, it was also one of the important part of the amendments when our legislator obliged social media providers to block accounts of those users who post some hate speech information, who post some information about terroristic activities, or also those who in some kind of criticize current Russian governments and their government officials. And it was very controversial, of course, pack of amendments, and it's still valid. And why it was implemented, because we had a series of journalistic investigations about Russian government officials. So that's why it was introduced so quickly and currently live in our reality. And it's still widely criticized by data privacy activists due to its limited access to the freedom of the expression in some cases.
Indeed, and actually what is very interesting that is also emerging from this discussion is that there are a lot of different topics that actually are converging even more because of their natural connection, but also because BRICS countries are, over the past years, have been starting to share good practices or bad practices, depends on how you look at them, and they are increasingly adopting very similar approaches. The case of the current fake news bill that Danilo was mentioning, and also Konark was mentioning, that aims at regulating social media, introducing some traceability requirements that are really, really similar to those that have been implemented very recently by India with the IT rules. It's an example of how BRICS countries are exchanging practices. Calling them good practices or bad practices is something that each observer can define according to its own criteria, but it's very interesting to see that these practices are increasingly exchanged, and the stated goal of the BRICS leaders is to further and strengthen this intra-BRICS cooperation on such topics. How they will do so, this is a 1 billion rupees, reais, rand, or any other BRICS currency question. And this is something we will see in the next months or years, very likely. It's something that I would really love to keep on discussing with you, I hope, at the upcoming Global Tech Summit organized by Carnegie and other events that we are very happy to organize together with our Indian friends and our BRICS friends in the next months. So stay tuned. With this injection of optimism regarding the BRICS future, I would like to thank once again our stellar panelists for a very exciting discussion and very thorough presentations, very detailed presentations. There is a lot of material for a lot of papers and articles to be written only by watching this session of today. So thank you very much to everyone. Please follow us on our social media, both Carnegie India and CyberBRICS Project and the Center for Technology and Society at FGV. Stay tuned, because more research and more material is to come in the next weeks, and especially do not miss our BRICS data protection mapping that you will find on cyberbrics.info. Thank you, and have an excellent afternoon or evening, depending on where you are in the BRICS. Bye-bye.
Bye-bye, thanks.